Ash versus Rebecca DeGrez, file 25-40752-LT. Mr. Blumberg, I know that you had a circuit court matter. Are you able to be with us for the duration now or not?
Well, Judge, if you recall, we were here a week ago, and at that time you told Mr. Grez to share with me the documents that she served on the court on an ex parte basis. I can tell the court about 10 minutes ago, while I was in the middle of another hearing in front of Judge Mertz, that Mr. Grez hand-delivered these documents to my office. That's clearly not complying with the court's order.
Ms. DeGrez?
Yes, I do apologize. Well, given the holiday last week, I did attempt to deliver the documents in person on Friday to Mr. Bloomberg's office, and I found them to be closed. So I definitely apologize. I am like a single mother handling a lot of things, which is not an excuse, but I did make an attempt, and I very much apologize. So I'm ready to proceed. There's not very much in the packet if you would like to look it over.
Judge, I don't want to restate the obvious, but she hasn't even complied with your direct order. There is no defense to this case. There was a mediation agreement that required her to be out of the premises at the end of March. She is a holdover tenant, hasn't paid rent, and if we're going to go forward, that's one thing. But if the court considers these papers, I'm going to strongly object to that.
All right, Ms. DeGrez, I gave you plenty of time to mail, to walk over, to whatever you needed to do to get the documents to Mr. Blumberg's office. You will have a chance to testify today if you want to. We will go forward with that, but I'm not going to consider any documentation that you gave to Mr. Blumberg 10 minutes ago or 15 minutes ago or whenever it was today. That's simply not enough time for him to have notice of it, to be able to react to it appropriately. I wouldn't let him do the same thing to you either. So we've got to be fair. So yes, ma'am, you have a question about that?
It's not directly related to this hearing, but there have been times where I wasn't presented with documentation that he presented to the court, and I was caught unawares. But I definitely apologize. It was not my intention. I did try to get it there on Friday. Mm-hmm.
I'm not disputing what you said, but he didn't have it. Friday was the 4th of July. Everybody's closed. I mean, that's a national holiday. Everybody's closed on the 4th of July, and I think everybody knows that. So whether you try to do it or not, I appreciate the effort, but there's no way that anybody's going to be present to take it on that day. So you will be allowed to present whatever information you have personally, but I'm not going to review the documentation that you submitted in the court file in this manila envelope that you submitted to the court. Mr. Blumberg, this is your complaint. How do you wish to proceed today by way of witnesses?
I have, again, only glanced at these documents. None of them really have to do with the issues, but in the sake of being fair, I'm prepared to agree to reschedule this. I don't care whether you review these documents or not. In my 30-second review of them, they deal with custody issues and things other than the landlord-tenant matter. But I'm willing to reschedule this where the court will have the opportunity to hear all the evidence.
Ms. DeGrez, is that what you want to do too? You want me to consider these documents with this adjournment?
I apologize, Your Honor. I'm just thinking for just 10 seconds.
Yep.
I just want to process
Please
that.
take your time.
I have everything in front of me. I'm organized. I'm ready to proceed. I'm well studied on the matter. If you care not care, but you cannot consider the envelope, I accept that. I feel like things keep getting rescheduled to my own humiliation. So I would like to get the matter settled.
Mr. Blumberg, are you ready? The case is with you to start, and then we'll hear from Ms. DeGrez afterwards. How do you wish to proceed?
Judge, let me, if I may, just take a moment to give you an overview of where we're at in this matter. Mr. Grez is the mother of my client's child. in the midst of a custody dispute and parenting time debate, the parties came to an agreement whereby Ms. DeGrez would be able to remain in the residence owned by my client, and that is at 30 Gaylord, Michigan. She was allowed to stay there for a period of time with the understanding that at the end of March of this year, she was to vacate the premises. That was memorialized in a mediation agreement between the parties and signed by the parties and their respective counsel. In consideration of that, certain monies were to be deducted from Mr. Dash's child support obligation. Well, March came and went, and Ms. DeGrez has remained in that property since then. She's been served properly with a notice to quit and a complaint to recover possession of property. Her defense is, as I read it, or at least as I hear it, is that she's a single mother and she has no place to go, and there were other, I guess, conditions that she believed would somehow allow her to stay in the property. The reality is that she has no legal right to remain there. She's been a holdover tenant since March 31st, and we are simply seeking the court to enter an order to recover the property for my client. Mr. Dash is here today, if necessary, to testify to those things that I've just represented to the court.
All right. Ms. DeGrez, do you disagree with anything that Mr. Blumberg has said?
Yes, sir. If I may provide background as well, just briefly. I am the primary caregiver, sole caregiver of our shared minor son, Colton, and I have maintained the stable residence at the plaintiff and I did enter into a mediation agreement, which was dated August 1st, 2024. There were specific terms in that agreement that do apply directly to our situation now. First was conditions related to payment of the arrears by the plaintiff, which was conditional then on my move out. There were additional financial and logistic responsibilities, as well as within the mediation agreement, there's a mutually agreed upon review to revisit mediation before summer 2025. I did make several attempts with community mediation services. They did reach out to James and Mr. Bloomberg, and my attempts for further mediation were denied. There was no final eviction or move out date unless said conditions were fulfilled in good faith. And there's more. There was no official lease. It was just the date in the mediation agreement. There was no official agreed upon terms outside of that date, with the various conditional matters I had already stated. Additionally, Mr. Dash did unlawfully lock me out on March 18th, 2024, violation of MCL law 600.2918. I do have video proof from the Michigan State Police, 2 10-minute videos with Trooper Hop of Mr. Dash changing the locks on Colton and I, and not allowing us back in.
What was the date on that? What was the date of that?
March 18th, 2024. So this would have been just as like within process of trying to get the PPO.
Of 24 or 25?
24.
Well, that would have been before the lease agreement or the mediation agreement, I mean?
Yes, and there was no, I asked for a lease. I was never given a lease.
So the illegal lockout, you say that there wasn't a lease agreement. How did he illegally lock you out if there was no lease agreement?
So this was documented in the PPO. Not resistance. When he had disputed the PPO, there was like a 3-hour court we had with Honorary Judge Mertz, and so this has all been documented. I would think well documented.
I'm not disputing the documentation, but the question I have is how would it violate the landlord-tenant law if there was no lease agreement and this happened prior to the mediation agreement?
Due to domestic situations at the time, Cole and I were living there by ourselves, and Mr. Dash had become very threatening. So I left the house for the night to go to my mother's. And then when I returned the next day to try to get Colton's things, he had locked us out. And so I had requested police assistance out of Pier, and they did record that interaction. That was Trooper Hop. So there's never been a lease in place is what I'm saying. And I've definitely tried, but I believe it's always illegal to change the locks on someone's place of residence, which it was clearly mine established since November 2019.
All right, but then you stayed with him for the end of March, April, May, June, July, and then August before the mediation agreement, right?
No, sir. Mr. Dash was not present at the home after a domestic incident in August. And
So up to that point, were you residing together?
up until August 2023, yes, until that recorded domestic incident, we were, yep.
So you're alleging they changed the locks in March of 24?
That is correct, sir.
Then you reached a mediation agreement in August of 24. All right, I just wanted to make sure that I understood your timeline. Thank you.
Okay, I have more in case you need more.
Well, let's take your statements one at a time. Mr. Blumberg has said that there was a mediation agreement, and it appears that you agree with that. And I'm looking at it. It's dated Thursday, August 1st of 2024. And it does say down near the last paragraph, the opening sentence says, both parties agree that Rebecca will stay in the home owned by James until March 31st, 2025. Am I quoting that correctly?
That is correct, sir. Based on the conditions.
You are alleging that there are some caveats to that, some conditions on that?
Absolutely, and other illegal bad faith things.
I'm sorry, I didn't hear what you said.
I apologize for interrupting.
No, you're fine.
I said as well as further actions by the things that I would consider illegal and against, like the eviction in general.
Let me take these things one at a time then, so I can understand them in order.
Okay.
What is your first reason for believing that there's an additional condition in play? Start with your first one, and we'll take them in order.
Okay, and just one little bit of background, the mediation did go for hours.
I'm again having a hard time hearing you, ma'am.
I'm so sorry. I keep trying to speak up. It could be my computer as well. I do struggle with Zoom. So during the mediation agreement, it did go on for hours. I was under like severe emotional and mental duress, and I did agree because I felt I had no other choice.
Judge, I object. First of all, as you well know, what goes on at mediation is confidential. The mediation agreement reflects the agreement of the parties and their attorney. She was represented by counsel at the mediation. So any discussions about what went on in mediation, I believe, is improper.
All right, ma'am, counsel is correct. An agreement is an agreement. It really doesn't matter how it got there or when it got there or under what circumstances it got there. This is an agreement. It appears to me that has this been entered in a court order that solidified this? I assume in the custody proceedings?
Yes, Judge, it has.
Ms. DeGrez, do you agree with that this has been solemnized by a court order so that it's a binding agreement on the parties?
Yes, sir. I have the dates here as well. It was with Honorary Judge Mertz. I would just like to add, though, if just given the context of domestic matters and like the threat, like I felt very threatened. I still do. Ma'am,
whether you felt threatened or not isn't going to change anything. If this is a court's order, out of this he is child endangerment, because it's not a statutory phrase or a violation. I also find that it's not neglect or abuse under these exact circumstances as I have them today, because you are able to provide, even if he was to kick you both out, he knows that you are able to provide for the child's immediate safety and find the child an appropriate place to stay immediately thereafter. So I don't find that that is a proper basis for action to extend the time period for today. Is there any other condition that you would propose?
May I just point out a specific law?
Go right ahead.
750.161. I hear you. I understand what you're saying. In section 161 of that, in reference to Mr. Dash, a person who being of sufficient ability fails, neglects, or refuses to provide necessary and proper shelter, food, care, and clothing for his or her spouse or his or her children under 17 years of age is guilty of a felony, punishable by imprisonment, etc. He meets all of these things. Like, he has not provided necessary shelter, food, care, clothing. Yes, just to give you, because you had said, and you are correct, that's just like a very simple, like stating what the law is, the first one I named, but this one kind of fleshes that out a little bit more. But I do accept as well what you are saying. I do not feel like we can look at this from an objective perspective, as this just my landlord. This was our family home. We worked for together, paid it off together. There's no mortgage payment on the house. And I'm trying to advocate for myself and my son. Mm-hmm.
I don't have a problem with you advocating.
I do not.
I don't have a problem, ma'am. Ma'am, hang on. Oh. I don't have a problem with you advocating for yourself and your son, and I think you're doing an admirable job. So that's not an issue. The issue is, that's all that's in front of me today is landlord-tenant. Mm-hmm. Does a landlord have the right to remove a tenant when there's an agreement between the landlord and tenant to move at a certain date? And the answer to that question is yes, he does. And simply by removing the tenant, if the tenant has a young child, does not cause the child to be neglected or abused, because the tenant can provide for the child's immediate welfare by getting a motel or getting a hotel or going to a homeless shelter or renting another place. So it is not abusive or neglectful, even if the landlord is the father of the child and knows that the child is going to be removed from the home that the child believes is its long-term home. That may have some emotional impact on the child, but by and of itself, I do not believe that it is neglectful to the point where it would overcome the landlord-tenant laws. If you disagree with me, you may certainly report it to Child Protective Services. They may do an investigation. And if they believe that I am incorrect, they can bring that by way of a child protective proceeding in court, and I would review it again at that point. But as of today, the landlord simply enforcing an agreement reached with the tenant for a date to be removed from the home does not amount to abuse and neglect. Do you have any other conditions that you believe would allow you to stay within the home longer than the date that you agreed to?
Let me just look. They are rather backed up at CPS too. They're very busy over there.
I deal with them every day, so I know exactly how busy they are.
I know.
Correct. So
they really are. They're doing the good work.
Judge, can I respond while she's looking whatever it is she wants?
Yes, sir.
If anyone is neglectful in this situation, it is Ms. DeGrez. She is the individual who cannot provide for her child. My client, at a moment's notice, can provide this child with housing, food, and clothing. So if she wants to go down that road, she is the neglectful parent, not my client.
Sir, I would love to go down that road. Like, what, 230 miles away? 230 miles away,
sir. Ma'am.
The false narrative and the humiliation is not acceptable. Ma'am. I'm sorry.
As I've said before, I'm not going to consider what Mr. Blumberg said, because I'm not here on abuse and neglect. I'm not here on custody and parenting time. I'm not here on any of that. This is landlord-tenant. I don't take what Mr. Blumberg said as a statement of fact. He's an advocate for his client, and that's all that was there for. So please review your notes, do whatever you need to do, take a minute to think about what you need to do. And then all I need to know is, do you have any other reason for believing that you can stay longer than March the 31st in the home?
I guess they have a closing or yes, I can talk. Very good.
Go right ahead.
I would request the court not to think of this situation as a contractual dispute. It is a matter of child safety, survivor protection, and a parent's right to remain housed while completing a master's degree and caring for our shared son. The plaintiff's actions are consistent, the long-standing pattern of abuse and retaliation, and this should be evaluated as such in any legal setting, especially as it pertains exactly to this. I don't believe it can be looked at objectively as a landlord-tenant typical situation that you described. I do understand what you have said. I agree with this very much. I would like the court to consider the non-performance and retaliatory motives of the respondent with this. And please just uphold my continued right to reside at my home at minimum until a mediation session can be held and we can agree on further terms. It's in the best interest of our child. But again, like you said, I realize this is not a custody dispute. From my perspective, I felt like it was in bad faith the arrears weren't paid, and that was verbally discussed, agreed upon. And it is to my detriment that it's not an addendum within the mediation agreement. I did request an addendum to the mediation agreement in January as well, and I have been denied continually. That is all, sir.
All right. Mr. Blumberg, do you want any response?
Just briefly, Judge, and I'll try to stay on point. Contrary to what Mr. Grez says, this is a contractual situation. There was an agreement freely and voluntarily entered into by the parties. It specifically gave Mr. Grez the ability to reside in that place until March 31st of 2025. In spite of our numerous requests to peaceably ask her to leave, she refused to do so. And we had no choice but to bring this action seeking the court ordering her removal from the property and retaining possession to my client, the rightful owner. This isn't about custody. It's not about child endangerment. It's about my client's legal right to retain his property. Thank you.
All right. Mr. Grez, I can certainly understand, as I said before, the emotional impact that the request to leave the family home and the whole home that you've shared with your child for a long period of time, why that would have some emotional connection to you and why that would be difficult, probably economically, emotionally, socially. However, this is nothing more than a common, ordinary landlord-tenant matter. This is a holdover on a verbal lease, if you will. The parties mediated that as a part of the custody and parenting time portion of your relationship. That was reduced to an agreement. The parties with counsel agreed to have you move from the home on March the 31st. Mr. Dash and Mr. Blumberg are simply asking that the court now enforce that through the appropriate contractual landlord-tenant process. You have been given every opportunity to produce to me a landlord-tenant reason why I should not do that, why I should allow you to stay within the home for a longer period of time, and you've not given me any legal basis for doing so, other than it would be hard for you, it would be hard for the child, and you would like some grace. Unfortunately, I can't make one side agree to something that they do not wish to. The parties reached this agreement. I can only enforce what the parties agreed to, and that's what I'm going to do in this particular case. Mr. Blumberg, do you have a proposed judgment for me to sign today or not?
I do not, Judge. I will provide that to the court tomorrow, certainly at the earliest, or maybe later today. Although it's
all right. Why don't we do that under a 7-day notice? she would be required to be out within 10 days of today's date. That's the most time that I believe that I would normally be allowed to give her. So, ma'am, you have 10 days from today's date. Mr. Blumberg is going to send me the original and send you a copy of a proposed judgment. If you disagree with, not with what my ruling is, but what his order says, whether it if it differs from what I have said, then you have the right to object to it, and you must do so in writing. If you don't object to it, I will sign it in 7 days, and it will become the order of the court. Do you have any questions, ma'am?
Just, I suppose one, a lease would have been very helpful. The fact that there's not one, I think is a glaring oversight to all of it. Like you said, it's just one sentence. And I begged for a lease.
I don't disagree with you that a lease would have been very helpful, but it wasn't there, and I can't go back and change history. All I can do is base things on how the law typically works. There are lease agreements where nobody writes it down. It's not supposed to be that way, but they do that. People let people stay in their house all the time, and if they hold over after they've been told to leave, we do the landlord-tenant stuff. So it's not out of the question to have a non-written lease. And so that's what you have in this particular case, a non-written month-to-month lease. You're a holdover after you agreed to go. And so I'm treating you exactly the same way I would treat anybody else that comes before me with the same kind of claim. You have these rights. We went through the reasons why you might stay, and I found for the other side, and I believe that they are being upheld in the proper way to proceed. So all I can say is Mr. Blumberg is going to submit an order that comports with what I've said today. You have 7 days to object to that once you receive it. If you don't object, I'll sign it. If you do object, we'll have another hearing on it, but you've got 10 days period to be out. Okay? All right. That's all for today then. Thank you very much.
Judge, can I just ask one last thing? I want to make sure we all understand.
Yep.
Well, she has the right to object to the form of the order, but not the court's ruling. I'm not sure she understood that.
That's correct. And she has the right to appeal if she wishes, but she'd have to do that appropriately. And I don't know whether the next court would accept it or would adjourn it or hold it in abeyance. So all I can say is that's the ruling that I've made. Mr. Blumberg is going to submit the order, and we'll take care of things in the due course as they proceed on down the road. Thank you all very much.
Thank you.
The courtroom takes an unexpected turn. The judge immediately shuts down several pieces of evidence the woman tried to submit at the last minute, explaining that the opposing attorney had not been given enough time to review them. The court stresses that fairness in legal proceedings matters just as much as the claims themselves. Undeterred, the woman begins presenting her defense verbally. She argues that the mediation agreement included conditions that were never fulfilled, particularly regarding child support payments and financial obligations. According to her, those unmet conditions should prevent the eviction from moving forward. The judge listens carefully but repeatedly brings the discussion back to the central question: what exactly does the written agreement say? Because in court, speculation and feelings rarely matter as much as the exact language of the contract. Now the excuses start piling up. The woman claims that because there was never a formal lease agreement for the home, the eviction shouldn't proceed in the usual way. She argues that without a written lease outlining detailed terms, the arrangement should be treated differently under landlord-tenant law. But the judge quickly dismantles that argument. He explains that verbal agreements are still enforceable and that the mediation document clearly states the date she agreed to move out. In other words, the absence of a traditional lease does not magically grant permanent residence rights. The judge also points out something crucial: the homeowner has already revoked permission for her to stay. At that moment, the legal reality becomes clear. Without consent from the owner or a valid legal defense, remaining in the property becomes extremely difficult to justify. And finally, the judge delivers the ruling. Acknowledging the emotional weight of the situation, he explains that the court can only enforce what the parties originally agreed to. The mediation agreement clearly states that the woman was allowed to stay in the home until March 31st, no longer. Since she remained months beyond that date without legal justification, the homeowner has the right to recover possession of the property. The judge orders that she must vacate the home within 10 days. While she retains the right to object to the written order or pursue an appeal, The decision itself is final. With that, the courtroom session comes to an end. What began as a complicated personal dispute ultimately comes down to a simple legal principle: agreements made in court must be honored.